Okay, thank you all very much. We have a guest speaker here. Dean Garcia would like to just say a few words to you, and after he does, then we'll do the drawing. So you guys who are here promptly today, you get the benefit of the drawing. And then we'll go into the material for today. Dean Garcia.
You're in the last stages of training for the marathon. You know how long a marathon is? 26.2 miles. You know how many subjects you have to study for the bar? Dean Singer just told me not too long ago, 27. And that's why I say you're in the last stages of studying for the marathon. Experience with the bar. I remember it vividly. I decided not to come back here. Distractions, and I couldn't afford those distractions. Passed the bar, and that was one exam I only wanted to take once. That's one exam I never wanted to take twice. I can tell you, though, that in the 10 weeks that I spent for the bar, I learned more law than I ever thought I could ever learn in my lifetime.
Where's the fishbowl for the tickets?
Enough. You will find it.
I
found it already. I would rattle off elements because I've studied that stuff over and over and over again. I don't know if you're at that stage. By the way, I have a present for you. At the end of the bar in Tampa, we'll have a reception. It's a reception for alumni, but I don't know. Have you all of you gotten your invitations? If not, Peter Kelly, Dean Kelly, will send you an invitation, and we will have food and drinks. How's that? That give you something to look forward to?
Fly bag.
What state of mind were you in, and what physical shape were you in when you performed the best on an exam at law school? Ask yourself that question and do that for the bar. What do I mean by that? People thought that I was going to flunk the bar, and then I was crazy. Because when I got to Tampa, I took it in Tampa too, by the way. When I got to Tampa, they said, Garcia's nuts. Look, he's running. He's not there shuffling cards. And I said to myself, I've studied this stuff for so long and for so much, and I know what's worked for me in terms of succeeding in an exam, that if I don't know this stuff now, I never will. That's a true story. I passed the bar, thank God. You know how I found out? It was the day before the internet. I had to go into something that you only see in old movies. I was clerking for a firm, and I said, can I take a lunch break? And they said, yes. And I went into the phone booth, closed it, dropped my quarter in there, dialed the Florida bar, and that was the longest wait of my life. But I had a research assistant who has a better story than that. This is a true story. When he told me, I freaked out. I said, are you kidding me, Ron? He was interviewing for a third DCA clerkship with Judge David Gersten. And he said, Prof, I went in there. And Judge Gersten said, hey, did you take the bar? Yeah. Are the results out? Yeah. When? Today. Have you had a chance to look? He said, no. He goes, here's a computer. Go on there and tell me what the results are. He said, if I would have passed that exam, I would have been really embarrassed. I said, you're kidding me. He says, no, I got that. Oh my God. By the way, it's not going to do you any good. But what we lobbied for, we just went, all the deans went for a dean summit at the Florida Bar meeting in January. And what we lobbied the bar to do is to cut the number of bar tested subjects from 27 to 14. Whether they will listen or not is a whole different matter. And it's not going to do you any good if you go like, oh, that's great, Garcia. I could be maybe somebody else will benefit from having to study 14 instead of 27. But hopefully that will happen. The ABA, by the way, just passed a resolution, the House of Delegates, to encourage each and every state to do the uniform bar examination. Don't know whether that will happen or not, but it passed yesterday or the day before yesterday. When New York went to the UBE, that seemed to be the trend. By the way, if it makes you feel any better, the reason I told you the story that maybe your successors, graduates, will have it better than you. When I graduated, right before I graduated, they used to scale the bar passage rate in the Florida bar, and it usually hovered from 110 to 118. And then all of a sudden, I get this notice from the Florida bar that says, 133 in both exams is now the norm. And I go, Lord, please forgive me for my sins. What did I do? And I had a buddy of mine who said, I passed for the 116. What do you got to get? 133! 133. I said, are you kidding me? Which spurred me to even study harder. Look, I still have nightmares about taking exams, about not finishing. I told that story, which is true. I still have nightmares where I'm in a law exam and I don't finish a question. It happens. This too shall pass. And I know, no pun intended, that you will pass. Because I know you've been working hard at it. It's a marathon, it's tough, it's a lot of material to absorb. I was in your position once, so was Dean Singer, so was everybody else. Ultimately, you'll get your license. You get your license the first go around, right? Yeah?
Yeah.
Yeah! Say yeah! He goes, no, we don't have enough energy to yell, Garcia. Yeah! You will pass. You will pass. You're in very good hands. And I know that you will. Look, Dean Singer, isn't it impossible to know this 27 subjects backwards and forwards?
Oh, you can't know everything. It's just not possible to know everything. Just have to know enough.
Okay. So I think that if you work diligently as Dean Singer has told me you have, you know enough to get by. Get by, I mean pass. Because nobody asked you what your score was, right?
Yeah.
They just want to know whether you're licensed or not, right? That's, in essence, the bottom line. This is a true story, too. When I was a state attorney, there was a guy that had a perfect score on the Florida bar. He couldn't find his way to the courthouse. He got a perfect score! And he said, I got a perfect score on the bar. Well, first you got to find your way to the courthouse. So, you two, you'll do well. Look, I see it in your faces. It's painful. It's rough. Sort of like training for the last turn of the marathon. And just like in Boston, they call it Heartbreak Hill at the 20th mile. When you get to the 20th mile equivalent, when you're taking the bar, hang in there. Hang in there. Hang in there. And you too will pass. So, good luck to you. I hope to see you at the reception, at which time you can relax, and the food and drinks will be on us. Good luck.
Thank you very much, Dean. And we have one job for you to do, and
Is there
anybody else on a ticket?
The one I say? Oh.
Okay, because the odds are very good today. For
Yeah, the odds are
Dean Garcia, you have to draw.
Oh, wait a minute, the raffle!
The raffle.
Don't look. I don't have my.
She forgot the fishbowl.
Just pull anything out.
One.
That's it.
Who do we have?
Alisa Ruiz.
Yeah. Okay. All right. Congratulations. Okay.
You won the
Once, twice, do I need to do another selection? No? I get their prize later?
Okay.
Don't forget to sign in again, like I told you, your attendance, because many of you have 6, so one more will give you the free, and here's the attendance sheet.
Question about if you win the raffle, just in case I win it. Does it cover up to $300
For one night.
One night.
Up to $300 for one night.
If your one night is 117.
That's it.
That's good.
Yes.
Yeah, so good, because I was finding 70 over that.
Yes.
Anybody need any earplugs?
Oh yes, earplugs, and remember that you are allowed to use earplugs. I would recommend that you use earplugs, but what you can't do, of course, if you have your own, like I have earplugs that I use, you can't use anything that's wired. So you have to, or anything that looks like it could contain or transmit information. Yes, ma'am.
Are you allowed to take highlighters? Like, I know it's pencil, but no highlighters?
Nothing.
No pencils.
Nope. They will supply you with what you need to write if you're going to write, because unfortunately people have brought in what looks like a highlighter and turns out it's a scanner or a little phone, like Get Smart. So no.
Take the rest of this?
Yeah.
Can I take the rest of them, or should I leave a couple?
Leave a couple and then you can take the cart and the rest of it. Yeah.
So not even the number 2 pencils to fill in the bubble?
They're supposed to. I'll confirm that, but they're supposed to supply you with everything, because. Yeah, I will confirm that, because you're not allowed to bring anything in, and it's because it's like I say, it's Get Smart. You could have a little transmitter at the end of that pencil, that number 2 pencil. Question?
And then non-hooded sweatshirt, right?
Okay, the deal on the sweatshirts here, you definitely cannot wear a hood up. And that's unfortunate, because that would allow you to screen out a lot. A couple of exams ago, we asked Michelle Gavani, who is the head of the Florida Board of Bar Examiners, and she said, you can wear a sweatshirt that has a hood as long as you don't put it up. But honestly, if I were going to go in, I would just take a sweatshirt without a hood for this reason. You don't know who's going to be stopping you at the door. And, proctors sometimes get overzealous. Nobody I know, but they have a job to do. And if your proctor stops you and says you can't take that sweatshirt in, and then it's freezing inside, which it is likely to be, then you're going to be uncomfortable the whole exam. So I would just plan ahead and take something that doesn't have a hood.
Another question. I was planning on bringing 2, because I have a sciatic problem. So if I'm sitting down on a seat that doesn't have cushion, it starts to
Yeah, I understand.
hurt.
Yeah.
So I don't know how the chairs are going to be. Do you know?
Well, the chairs are uncomfortable. I'm gonna tell you, and I have similar issues, because I have back issues. Plus, I have no padding, so I can't sit in folding chairs for any length of time, because it does hurt. What you can
I was planning on bringing 2 sweaters. I could put one
Oh.
under me.
that should be fine.
Okay.
That should be fine. And you could also try to contact them. It's probably a little bit too late. They, in some circumstances, they'll let you bring a cushion in if you've got documentation, but it's probably too late.
I think it's 7 days before you
Yeah.
can still get the.
Yeah.
I was given approval to bring in like my medication, but can I just bring it without the bottle and just be in the bag? It's not prescribed,
yeah.
it's Benadryl. and
Oh, okay.
EpiPen.
Okay, as long as, and there's no prescription that goes with
No
them?
prescription with the Benadryl.
Okay, but the EpiPen there would be. Is there anything on the EpiPen?
Not that.
Here's what you might want to do. Clear plastic bag, put the Benadryl in, put the EpiPen in, and can you do a little photocopy of your prescription for the EpiPen? Throw it in the bag. Just in case. They should be able to recognize an EpiPen and understand what it's for, but you just never know. Like I say, you don't know who's going to be proctoring, and the last thing you would want to do is have them not let you bring the EpiPen in, for sure. Yes, ma'am.
I know that we're not allowed to take water bottles or anything like that, but when we're going to go up to the bathroom or anything, do we need to, is there a process like here that you just go up and sign something?
Yeah, you have to take everything. You can't leave anything at your table. And you take it and you give it to the proctor, and then you can go to get a drink of water or go to the bathroom or whatever. And
You have to close and then put everything back. Oh, okay.
yeah, right. Yeah, and I have to tell you, it's a little more complicated than it was when I took the exam, because I can't, like I said, I can't sit for a long period of time. So I got up every hour on the hour just to make sure I could get up and move, if you will. And it was all, there was no computer at that point, so you just folded it up, handed it to the proctor. It wasn't a big deal. It is a little more complicated now. But if you need to get up, then don't hesitate to get up, rather than sitting there and dying of thirst or being extremely uncomfortable.
You just want to stand up next to your chair chair.
You could do that. I would ask permission, but you can without closing everything up if you're just standing by your chair. It's when you walk away that everything has to. Okay, other kinds of questions like that though, because I'm happy to try to answer them if I can. Yes, ma'am.
The extension cord,
Yes, very important actually. And
just tell me everything.
okay, the reason I say it's very important, I wish I had Amar here to tell his story, because he took an extension cord for his, probably the one that he had used for other things. He took that along and it was too short. And so he had to really scramble, because they're going to have strips running in between the banks of tables, if you will, and your cord has to be able to reach that strip, and you need something longer than normal. The exact length is, I think, on their website, and maybe when we take. Okay, I can look it up and confirm. Yeah, I'll confirm it on the break if I can. I do know, though, that you definitely don't want to take just a 3-foot extension cord. So take a nice, big, long, juicy one so that you have enough juice.
Sorry.
Sure.
One more. Do I need internet access while I'm
No,
taking the exam?
because you're gonna up
Just
afterwards. Yeah, and quite frankly, think about it for a second. They are going to go to great lengths to block the internet while you're in that room for the obvious reason. So yeah, it's afterwards that you upload, and they'll give you all the instructions that you need for uploading.
Well, they're using Samsung, so it'll block off everything from your computer whether you want to.
I know, but
I don't know if I needed it to open Samsung to begin with.
they have a whole. They're going to tell you exactly what to do and how to do it, and then they will
They sent an email though
Yeah.
explaining most
the
of
process. Yeah,
Did you get it like this week?
yeah.
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 You guys are doing great.
Yeah, so just follow the instructions. Yeah. No, I certainly hope no surprises. A couple exams ago, they had serious problems with uploading, but you should not have that problem because that's been corrected. Any other questions? Okay. Now, before we go in, we're going to start where we left off on Friday, last Friday, with Florida constitutional law. But before we go there, for those of you who are coming to the final session on Wednesday, and I know some of we're already seeing some people who've been coming regularly who aren't here. I understand completely, because you get close to the exam, you may want to just hole yourself up. But I will be here on Wednesday for whoever shows up. We are kind of limited in the time because we had to switch the time. There's somebody before and or at least somebody after the session. So I'm going to have to, I can't cover absolutely everything in the world. I would like to hear from you if there is a particular topic that you would like for me to talk about. Understanding that this particular session is not designed to go into detail about subjects. It's really too late to do a lot of detailed learning. The idea is to kind of get you thinking broadly and in an organized way about the various subjects, and so it is a broad review. One topic that we will not do in the Wednesday session is civil procedure. Now, you all should have gotten the email about Professor Nathanson's chat on Saturday. So his chat will be your last chance to review civil procedure. I'd much rather have him review civil procedure with you, because I know basic stuff, but I am not a civil procedure expert, and of course you know he is. We will, or he will actually, send you the link right before, well, about a half hour probably before the session on Saturday, because he won't know what the link is until then. And so you'll follow the instructions he gives you. You can go on. He'll be chatting, as he said, for an hour or so, and he will answer whatever questions you might have. So I encourage you to take advantage of that. Even if you don't have a specific question, log in and listen, or listen, view what's going on, because that can be a great review in and of itself. All right, so if there are no other questions at this point in time, let us go to Florida Con Law. It is, of course, impossible for us to do an essay on all the various things that Judge Shepard covered last week. Just don't have time. So I picked one that is Homestead with some wills in it, because it's an easy combination. And remember that they can test up to 3 subjects in an essay. If you get a Homestead question, and you very well might, they love to test it, they haven't tested it on the last couple of exams, and so it certainly is ripe for testing. It is a relatively easy question to answer because there's a structure. And so, you know, always think about the structure. It gives you a sense of confidence if you know how to write about it, whatever it is, before you go into the exam. Then you can just slot in all of the rules and all of the details. So if you would, as we've done, please turn to the end of the Florida Con Law question. Take just a few moments to read the question and find the issues in the question. right, let's see what we have going on in this question. Let's go up to the top of the fact pattern. So we start with Mr. Adams, who inherits a home, and they tell you it's on 1 acre of land in the city of Miami. So as soon as you see 1 acre of land in the city of Miami, you know, ding, 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 homestead. Always let those facts be your guide. So if you didn't write homestead there, and I'm assuming you all did, but if you didn't, then remember, take the hints from the question. And then we just pile on in information. Mr. Adams married Mrs. Adams in 1970. Homestead, married couple, you know, is all coming together. And they lived in the Miami home. Why is that important? Because it's got to be the permanent residence, right? Mr. Adams, the couple had 2 children. A son, Sam, born in 71, and Dot, born in 83. Now, of course, that's a long time ago now, but you look at the date of the question, and that's relevant, right? Because Sam is an adult, and Dot is not. Why do we care that Dot's not an adult?
It changes whether the homestead can be divided.
Exactly right. Changes whether the homestead can be devised. Because it cannot be devised if there is a spouse or a minor child. And right at the moment, anyway, we've got a spouse and a minor child. But, of course, next paragraph. Mr. and Mrs. Adams' marriage was dissolved in 93. What happens to her homestead rights at that point? They're gone. Because if they divorce, she no longer, of course, is going to have homestead rights as homestead rights. There's a little quirk that I'm going to talk about, though, that relates to this fact pattern. It is based in part, as these problems usually are, it's based in part on a case that was working its way through the Florida court system at the time the question was written. So under the divorce decree, Mr. Adams retained ownership of the Miami home. Okay, that's fine. However, the decree permitted Mrs. Adams and Dot to occupy the home rent-free until Dot reached the age of majority or until Mr. Adams died, whichever came first. That fact is significant because Dot and Mrs. Adams are making their residence in that home, and even if Mrs. Adams isn't entitled to homestead protection at this point, Dot is. And so that's significant here. Now, in 1994, Mr. Adams bought a 1-bedroom condominium located in unincorporated Orange County. So as soon as you see unincorporated, how much? 160 acres of land, got to be contiguous, of course, and improvements on the land. And he moves in and he lives there alone for 2 years. If he's there for 2 years living there, it might be his homestead. But if it's his homestead, right away you're thinking, well, wait a minute, what about the Miami home? And again, there's authority on that particular point. Interesting typo, which I didn't notice. In 1995, it should be the roof, not the rood. Rood is a cross that's by the roadside. The roof of the Miami home needed replacement. Mr. Adams obtained an unsecured loan from XYZ Bank to pay for the new roof. Why do we care that it's unsecured? It's not. Okay, if there's no security interest, then it's not going to fit into one of those 3 exceptions in respect to homestead protection, if the home is still the homestead. Now, in 1996, he moves back to Miami and lives in a rented apartment until another typo, wow, his death 1 year later. He moves back to Miami, so you think what? The Orange County condominium? If it ever had homestead protection, it's gone now because he has what word? What do we call it? Abandoned the homestead. During the period, the condo was vacant, suggesting abandonment, and he listed it for sale. If he lists it for sale, then that's certainly evidence of his intent to abandon. Mr. Adams died in an auto accident in 97. He has a validly executed will. Now here we see the homestead and wills come together, a fairly frequent combination, not unusual at all. Since it tells you that the will is validly executed, I would not take the time in this question to go through the requirements for execution. You've got a lot of other stuff to talk about, so take your cues again from the facts. And here we go You may recall from a few weeks ago when we did the trust question, what did I tell you about Bob?
Give it to him.
Just give it to Bob. Here he is again. Just give everything to Bob, you're done, and you can have an early lunch. Because his validly executed will devises all of his property to Bob the Bandit. It's always the case. The only significant assets in this estate were the condo and the Miami home. So we really have to figure out what, if anything, is homestead. Because can he devise the homestead to Bob the Bandit? No, he can't. Whatever the homestead is, because Dot is still a minor in the fact pattern, not today, but in the fact pattern, February 1999, she is still a minor. And of course, when Mr. Adams died, Dot and Mrs. Adams are still in the Miami home, bolstering the idea that that is homestead property. Now, he was uninsured at the time of his auto accident, naturally. Victim, the other person involved in the accident, filed a timely lawsuit against his estate, so you wouldn't spend time talking about what's required to file against the estate, and got a final judgment based on the injuries the victim sustained. But we know what about that final judgment? It's not what? It's just a judgment, right? Is it going to fit into any of those exceptions in respect to homestead? No, it's not. It's unsecured, so it's not going to have priority. XYZ Bank filed a timely claim against the estate for the unpaid balance of its loan to Mr. Adams. But was that loan, it wasn't secured by a mortgage. Interesting. So no objection that the claim was filed. That's nice. Yes, ma'am.
I have a question. The loan, though, was for a new roof, so would that fall into the mechanical lien?
No, it does not. Here's why. They wrote this question very carefully. That particular loan does not fall into that third category because it was a loan to him to hire somebody. It was not,
Directly to the person that fixes it.
Yeah. He got the money and then he hired somebody. So there is no secured interest here.
All those three super creditors, they have to have secured.
Yes, they do.
If it was secured, then yes.
Yeah, absolutely. It's got to be something that grows right out of the property itself. So taxes, mortgages, and mechanics liens. But in this case, it's set up so that it doesn't carry that security interest on purpose to see if you can see the difference. Okay, so now the only thing I don't like about this question, and you're less likely to see today, is that very broad discuss. Today you're more likely to see a pointed call of the question. So leaving that part aside, though, we've got a good question, and what are the things that we have to discuss? Clearly, we have to discuss whether we have homestead, and then second thing, how are we going to dispose of Mr. Adams' estate? So let's take a look first at the establishment of the homestead. And as I said, the nice thing about homestead is it's very elemental. So write your answer based on the elements. Break it apart. It makes it so much easier. And the first thing that we know that we need is the natural person. Yes, ma'am.
When I saw unsecured loan, I thought they wanted me to talk about secured transactions.
Oh, okay. They did. Oh, okay. Interest.
Yeah.
I
mean, I was going to talk about
Yeah.
everything
Well, okay.
but like,
Yeah, I see why you would. Now, when the question was written, they didn't test secure transactions. Oh, and they don't really have facts in there that take you anyplace with secure transactions, because if it's a secured transaction question, they're going to be wanting you to get into priorities or things like that, and the facts don't support it. So in this particular one, you'll see I have nothing about secure trans in the question. Of course, I also have the luxury of knowing what they tested then and what's not what's tested now. But really make sure that you use the facts as your base. Because even if there's a loan and it isn't secured, if there's nothing that raises Article 9 in the fact pattern, then don't spend time on it. Don't manufacture facts. You can't do that. All right, so establishing the homestead, first thing you need is that natural person, right? And I think Mr. Adams, as far as I can tell, is a natural person. The only thing to look out for there in the fact pattern, and it could certainly show up because there's a little bit of a split of authority, is if you put your homestead into a revocable inter vivos trust. Some people are doing that. If you ask Judge Shepard, because 3rd DCA has said what it thinks the rule should be, he will tell you very vehemently that it's okay. If you put it in the trust, it doesn't destroy the homestead, because there are 3rd DCA cases that say exactly that. But there are some bankruptcy court cases that say that homestead protection is lost. Florida bankruptcy court cases that say that if you put homestead into a revocable inter vivos trust, you lose the homestead protection. Why? Because it's not owned by a natural person. So should that show up in the fact pattern, and it could, then you want to identify that there's a little bit of a split. Whichever side you come down, you're going to have some authority. But you definitely want to recognize the fact that the law, and there's no Florida Supreme Court case on this particular point. If there were, it would make life a whole lot easier. Which again makes it ripe for testing on the exam. When there's a split of authority, it's exactly what they like to test. So at this point, though, of course, Mr. Adams did not put the property in a trust. And if it's located within a municipality, we already discussed, then you get up to 1/2 acre of contiguous land. And notice that they told you that his house, his residence, stood on 1 acre of land. So the house and 1/2 acre around it is going to be protected, but not all of the property will be protected. And people always say, well, what do you do then? Well, they can actually chop off part of the property and sell it if they can find a way to do it to satisfy the creditors without forcing a sale of the homestead. And of course, with the Orange County condominium, 160 acres, I don't think the condo had 160 acres attached to it. Probably not. So not an issue there. The only thing to look out for when it comes to homestead and the property located outside of the municipality. Judge Shepard actually mentioned it briefly last week. Again, there's a split of authority. What happens if you have a big plot of land, and it's usually going to be, kind of in the middle of the state of Florida, up there where all the cattle farms and all that stuff are located. You may have a residence on part of the property and some kind of commercial enterprise on another part of the property. The authority is split. Some courts, and again, no Florida Supreme Court decision on, some Florida courts have said as long as there's a residence on part of it and the land is contiguous, the entire 160 acres will be protected even though part of the activity is commercial. Others have said the opposite. We protect only the part that's residential. Again, ripe for testing just because there is a split. Here, it's not going to be an issue. Notice what we're doing though. We're going element by element with homestead. And if you follow this structure, any homestead question becomes very easy to write, which is your goal. Permanent residence, of course, and we know that Mr. Adams lived there with the family, and then Mrs. Adams and Dot continued to live there. And so it was his homestead at least until the divorce. And the question is, could it remain his homestead after the divorce? And the answer is yes, because it protects his residence or the residence of his family. Now, something to note here. You might determine, and we'll get there a little bit later, that the Miami home was the residence, and then he moved to Orlando, and you're thinking you can have just one homestead. Normally that's true. But there are some cases, and there is some authority, including that article that I cited there, that say that if you have a divorce, and or separation, it doesn't have to be a separation, an actual divorce, and one spouse lives one place and the other lives another place, usually with the kids, that it's possible to have two homesteads. because one protects the owner and his or her residence, and the other protects the family. And it's clearly what they were testing in this particular case. Abandonment. What do we think in this case? First, with the Miami home, when Mr. Adams moved out of the Miami home, did he abandon his homestead there? What do you think? Because he did move out, right? Did he abandon his homestead?
Yeah, he put it up for sale.
Not the Miami home.
Oh, no.
Orange County, yeah. But the Miami home, did he ever abandon it?
Yes, he left.
He left. Did he abandon it? What do you need for abandonment? Two things, right?
Permanent intent to not.
You need the intent not to return, and you need an act. But remember the definition of permanent residence. It's the residence of the owner or the owner's family. Oh, did he have the intent to abandon it in respect to his family? Absolutely not, because the divorce decree said that Mrs. Adams and Dot were going to live there. So he did not intend to abandon, I feel pretty comfortable saying that. He did not intend to abandon the Miami property, so there's no abandonment there. He left, you might have an act, but he didn't have the requisite intent. And remember also, of course, there are a number of homestead questions in the question bank that talk about temporary absence. And of course, he wasn't temporarily absent from the Miami home. He wasn't going to get to move back in there. But somebody who goes and comes, and it shows up frequently in the fact pattern, temporary absence is not going to be an abandonment. How long? There's one where somebody was gone for 6 months. That's just a question of fact, you know. And so you can decide how long is enough, always focusing again on that intent. Was somebody just taking the summer to go north to Maine to get out of the heat, or was there something else going on? Really?
Even if, let's say you do say that did a man left him with the house, can you still say that it's not almost like it's the mother's?
Well, that's what I'm saying. He did not intend to abandon it as the homestead for his family. Maybe it's not his personal homestead, which allows him to establish homestead in Orange County, but he did not abandon it as homestead for his family, right? And of course, remember, we're trying to protect that property, the Miami property at least, from forced sale, because we have these various creditors. And if you don't protect it, you're going to have to kick Dot out of the house. Maybe we don't care about Mrs. Adams, but we do still care about Dot. So I gave you some cases on abandonment there, remembering always that I include a lot more information here in these PowerPoints so that you have something to study. Now, Orange County condominium, we've got a different story, right? Because he does move in for a couple of years, and then what does he do? He leaves not just the condo, but he leaves Orlando, moves back to Miami, and what does he do with the condo? Puts it up for sale. What do you think? Intend to abandon? Yeah, I think so. Which makes Bob the Bandit very happy. So while he might have established, for that 2-year period, might have established homestead in the Orange County condo, it's gone when he moves back to Miami. All right, one thing to remember, and certainly Judge Shepard mentioned it last week, you throw it in one sentence because it never makes a difference in the case law. It's the most peculiar thing, and that's that $1,000 personal exemption, personal property exemption, that is in the homestead statute. So you get the homestead in terms of acreage, and then plus you get $1,000, which is different from exempt personal property. It's different from the family allowance. It's just this $1,000 thing that sits there that nobody ever talks about. So one sentence to say, and by the way, they get $1,000, and then you're done. But I would definitely mention it because you'll get points that a lot of other people won't. Yes, ma'am. Yeah. Yeah. Now, identification of a homestead, I put in a little bit about jurisdiction. I think I've mentioned before, not in this particular question, but I've seen more questions than you might think where they sneak in the wrong court. And they do it on purpose. It's not a mistake. They're just trying to see how awake you are. So always take a look at a court. If they tell you what the court is, here we're talking about circuit court, right? As the court for establishing homestead. Must you establish homestead before you have creditor issues? Actually not. So you don't have to go into court the minute you buy property and say, I hereby declare this to be my homestead property. You will get, of course, as time progresses, you're going to get a notice from the county asking about whether the property's homestead in terms of the tax exemption, the $25,000 tax exemption. That certainly can be evidence that it's your homestead, but you don't have to show that kind of evidence. All right, so what are we going to do with the property? Let's look first at the Miami home. And we know, again, he cannot devise the property if there are minor children of any sort, and Dot is a minor. So he could not devise the Miami home to Bob the Bandit. So to whom does the Miami home go? Well, Mrs. Adams was divorced from Mr. Adams, right? So we treat her as having done what? Having predeceased Mr. Adams. So who's going to get the Miami home? Dot's going to get the Miami home. I just want to caution also, suppose that Mr. and Mrs. Adams had not divorced here, because I'm seeing in and actually it's Dot and Sam. Sam's the son, and I'll get back to that in a second. I'm seeing some errors, not just in essays that I've read for people studying for the bar, but I always see it in my wills and trust class. People forget about the change in the law here that happened a couple of years ago. If you have a spouse and a minor child, of course, then no devise. If you have just a spouse, you can devise to the spouse. If you have a spouse and a minor child, you cannot devise even to the spouse. So how does the property pass? The traditional rule, of course, was that the surviving spouse got a life estate, followed by a remainder per stirpes in the lineal descendants in being at the death of the testator. So it would be a life estate, assuming no divorce here, a life estate in Mrs. Adams, followed by a remainder per stirpes in Sam and Dot. But the law changed. Mrs. Adams gets to make an election now. Don't forget about this election. I'm seeing people kind of blowing past it. And it's something they will test because it's a relatively new rule. She gets to choose. She can take that life estate followed by a remainder, or she can elect to take as a tenant in common with the lineal descendants. She gets half and the lineal descendants get the other half. In this case, again, if there were no divorce, Mrs. Adams would get one half, and Dot and Sam, sorry, keep forgetting the kids' names. Dot and Sam would get the other half as tenants in common. So 1/2, 1/4, 1/4. Don't forget about that election. I see a lot of people forgetting it. And quite frankly, today, the surviving spouse is almost always going to elect to take as a tenant in common. Why?
You can take it on the spot.
Okay, and think back to your property class. I know it's something you like to forget about. But how valuable, or invaluable as the case may be, is a life estate, a legal life estate, which is what's being created here. It's worthless. You can't do anything with it. You really can't sell it. I mean, you can, but you're not going to get very much money for it. You can't get a loan based on it usually, because they're going to use life expectancy tables to figure out if it's even worth giving a loan. It's not a valuable asset. So most surviving spouses today will take the the tenancy in common route. Make sure you include that in your discussion. So in this case, again, because Dot is a minor, the devise doesn't work, and Dot and Sam, don't forget about Sam, even though Dot is the minor and Sam is an adult, if the property passes by intestacy, which it must in this case because Dot is a minor, both Sam and Dot will share. What about that Orange County condo? If Mr. Adams abandoned it, which he probably did, who gets it? Bob the Bandit, right? Now, in determining that these parties get the property, oh, and I threw this in here, it's not the case here, but always when you look at the fact pattern, make sure you ask yourself whether the homestead's held in tenancy by the entirety, because it can be. And here's another place where people get confused. If the property is held in tenancy by the entirety, it goes to the surviving spouse. That rule on intestate distribution has no effect because the tenancy by the entirety is going to govern and the right of survivorship will take over. Absolutely correct. So don't forget about that. All right. So now we got to look at claims against the estate. And we're going to start with that family allowance. In this case, we've got a potential of $18,000 in a family allowance. Family allowance goes to the surviving spouse, if there is one, and lineal descendants, or ascendants. Here's a slightly different rule. It can be either descendants or ascendants that the testator either actually supported or was obligated to support. Well, we don't have a surviving spouse here because we treat Mrs. Adams as having predeceased. We've got Sam, who is an adult, and there's no evidence that Mr. Adams supported him, but we've got Dot, who is a minor, and no evidence that he did not support her, but even if he didn't, he was obligated to. So Dot is going to get that $18,000 allowance.
I'm sorry, Singer, I lost track of
Okay?
where the allowance came from.
Oh, we're going to go there, okay? All right? Okay? Yeah, let's, where is that? Let me go. I'll show you that and then we'll go back up someplace here. There we go. This is what I was looking for. Okay. When you have an estate, the personal representative does a couple of things. First thing the personal representative has to do is, besides getting letters of administration of court, is inventory the estate, figure out what the assets are and value them. And then the personal representative has to notify all creditors. If they're known creditors, personal service. If not, you have to publish in a newspaper of general circulation in the county twice. The creditors then step up and say, pay me. And of course, the personal representative has to pay the creditors before property can be distributed. Here's your order. And if you have not memorized this order, I would. Should you get a wills administration multiple choice question, or as you can see here, this is an essay involving homestead, and you still have to know the classes of creditors. So, first class, we take care of our own, right? Attorney's fees, always, we take care of our own. Second class, as you can see up there, is one that needs to be fixed. The amount in the second one has been there for quite some time, reasonable funeral and other expenses, but with a limit of $6,000, which is unrealistic today. The family allowance has been changed fairly recently, but they haven't gone back for whatever reasons and fixed the number in the funeral expenses. Any excess, of course, is going to fall down to Class 8, which is up there at the moment. Why not? No, because it's on the other page. So, first, the attorneys. Second, funeral expenses. Third, I always find this kind of interesting. The IRS is third. I can't believe the IRS sat back and let the Florida legislature put the IRS third, but there it is. fourth, an important category, which is the expenses, reasonable expenses, of course, from the last illness, the last 60 days of the last illness. Excess, of course, again, falls down to class 8. Fifth, there we go, the family allowance. All of this is getting paid from the estate before any distributions are made. And so I'll explain how that's going to happen in a minute, but right away we know $18,000 to Dot. And that $1,000 homestead has got to come out of someplace too. Class 6, and this is the most recent category, arrearage in court-ordered child support, which we don't have in this case. 7, debts acquired after the death of the decedent in running and winding up the decedent's business. And then finally, Class 8, which is your excess, and any excess in classes 2 and 4, and anything that doesn't fall into those other categories. Well, of course, the XYZ bank loan and victim's claim are going to fall in Class 8. So first thing that's going to get paid is Dot, $18,000, and then victim and the bank will step up. And you got to pay it from someplace, right? Before the gifts are distributed. The homestead will go to Dot and Sam free and clear of everything but those 3 exceptions we talked about. Taxes, here the IRS does step up. Well, it's not the IRS, but taxes on the property, mortgages, and mechanics liens, none of which we have in this case. So Dot and Sam should get the property, the Miami home, free and clear. The Orange County condo is what's going to have to pay the family allowance to Dot and those other 2 claims. So what is our personal representative going to have to do here? Sell the condominium, pay off those debts, and then whatever's left over goes to Bob the Bandit.
But the homestead in Miami went to the kids.
The kids in the plural, the 2 kids get it, and they should get it free and clear once again, even in respect to the XYZ bank loan because it wasn't secured. Yes?
Because the divorce decree says that it only goes to, it's supposed to be for Dot only until he reaches the age of majority.
Right, they get to live there.
Majority age?
No. It just says they get to live there, right? If you look at it, it's not a devise of the property to Dot. It just says that Dot and Mrs. Adams get to live there, right? So Dot and Sam take because it's homestead, and they take by the homestead rules. Now, the second issue, of course, the subsidiary issue is, they take the homestead, do they take it free and clear of Mr. Adams' debt? And the answer is yes. They will take free and clear of his debt as long as they are descendants of the grandparents of Mr. Adams, which they clearly are. Because if property that is homestead during the life of someone passes to somebody else, either by intestate or testate distribution, it retains protection from the owner's creditors, again, as long as the person who takes it is a descendant of the grandparents of the decedent. And clearly Dot and Sam are descendants of the grandfather of Mr. Adams. Okay, we got 2 questions, but go ahead.
But the homestead is for half an acre on this.
Correct. Yeah, and actually, a good point, which I kind of lost track of, but it's in here. Absolutely correct, because the other half acre is subject to sale. Thank you for that correction. Was that your pointer?
No.
Oh.
I mean, it was a little bit.
Yeah.
So the majority of Sam has the fact that I guess Dot, will both of them get it?
Yeah, absolutely. Remember, the prohibition against devise is triggered by Dot's minority. But because there can't be a devise, now the property goes either to the surviving spouse for life, remainder to the kids, or if there's a surviving spouse, he or she can elect. There's no surviving spouse here, and so it goes there, so there can't be an election. It will go to the lineal descendants in being. There's no qualification there. The statute says the lineal descendants in being at the death of the testator. That's Dot and Sam. So yes, they will both take, and they will both be, and the property will be protected because they're descendants of the grandparents of Mr. Adams. Now, it's not protected from their own creditors unless and until they do what? Establish it as their own homestead, which Dot probably will be able to do. Sam took off for another state, I think, so his creditors eventually might be able to get at his share of the property. Other questions? These are good. These are very good questions. Anything else that you're thinking about here? I have a little more material in here. I'm going to go back up for a second. I just want to mention, because it comes up in the cases, but honestly it's a tough thing to prove. It goes back to that loan which was not contracted directly for labor and materials. It was just a loan to Mr. Adams and then he went out. So that intermediate phase, if you will, of giving the money to Mr. Adams and then he goes and hires somebody to do the roof prevents the third category from applying. But there is something called an equitable lien based largely on fraud. If what somebody is doing is setting up a transaction, not really evident in the facts here, but setting up a transaction to get around the protection of the homestead statute, then you might have an equitable lien. But it's unlikely that they're really going to test that. Again, I throw it in there just so that you are aware of it. A tough thing to prove and always will be based on some kind of fraud in the transaction. Yes, ma'am.
Generic.
Mm-hmm.
So people answering this question was in 1999.
Mm-hmm.
So when I answer my question, if they're telling me something happened in 2003, I do the math up to 2016.
Oh, good.
Unless they
Oh,
say
yeah. Good point. They aren't likely to do what you just described. It's a very good point. Usually they're going to give you dates that are current. And so that you don't have to worry about the old law. Where might it show up right now? The trust anti-lapse statute was changed almost 2 years ago now. And so could you have a question where you got to stop and say, wait, do I apply the old one or the new one? Maybe. They usually don't do that. I can't promise that they won't. And I hope they don't, because the trust anti-lapse statute has changed so many times that it's really not fair for them to try to play those games. But then it's the bar exam. I can't tell you that it's going to be fair. So look carefully, though, at the time frame that they've set it in, and be aware that you're probably going to apply the current rule. Another place where it could come up, for example, this is an older question, and it does not have a trust in it, but suppose that it had a trust in it. At that point in time, trusts were presumed to be irrevocable. The change to a presumption of revocability didn't occur until 2007, something like that. Anyway, so 1999, a trust would be presumed irrevocable. It's unlikely that you're going to get a question where you have to stop and say, wait a minute, is this trust presumptively revocable or irrevocable just based on the date? That's, I think, not really a fair question.
And then like procedurally,
Mhm.
if it wasn't about the laws changing, would I assume I'm dealing with
When you say,
16? So like,
uh-huh.
This was obtained a final judgment in 98.
Right. It's just an old question. The dates would be obtained to final judgment in 2015 or something like that. So you wouldn't have to worry about statute of limitations or anything like that. They won't do that. I take the questions as they were originally written, but as you've noticed, I answer them with today's law. Because I don't want to, if I mess with the dates, then somebody says, but wait a minute, that's not the way the question was written in the book. So I leave that part. You will not have to wrestle with that particular point. The dates will work. I've never seen them really play games like that with the dates. Question?
The trust anti-lapse statute is that it has to be a descendant of have the grandfather, that's the current law.
Right.
Before it didn't.
That's correct. For a while, the trust anti-lapse statute had no relationship requirement. It now has one. What they were trying to do, but did so very inartfully, was to make the wills and the trust anti-lapse statutes parallel. They did not do a good job of it, but that was what they were trying to do. And should you get an anti-lapse issue, I would just apply the new rule. I don't think they're gonna, it's just not fair for them to try to play games with the dates. Other questions on this or homestead or anything in trusts or wills? All right, yes, ma'am, question? Yeah, go ahead.
If it's okay.
Yeah, go ahead. And if it's too specific, I'll say we'll talk about it later, but go ahead.
It has nothing to do with this stuff.
Okay.
It's from property.
Okay.
What is the difference, because I can't remember right now, I can't retrieve it. What is the difference between, I know lapse is when there is no longer the person. Now there's abatement.
When you abate gifts, redemption is what you're thinking about, probably. Okay? They're all A words. And there are a bunch of A words in the context of wills. Abatement means that there isn't enough money to go around to pay all the creditors. So you abate some of the gifts to get the money to pay the creditors. Redemption means the will, for example, devises Blackacre, in this case, devises the Orange County condo to Bob. And then when Mr. Adams died, he no longer owned the Orange County condo. That's redemption. Okay? Yeah, and vocabulary does matter, especially if you're writing an essay. I can tell you that, and it's kind of scary to me, if you go back a ways in the study guides that are posted by the Florida Board of Bar Examiners, there's a trust question from a while back. And they picked a student answer, and I have no idea why they picked this particular student answer, because the student wrote for 4 or 5 pages about an intravenous trust. Intravenous trust. I'm not kidding. You can go back and find it. And I read that answer and I'm thinking, this student's going to fail my class, and yet they published it. So, vocabulary, inter vivos, not intravenous.
Maybe the computer.
It was handwritten.
Oh.
I think it was handwritten, but who knows? Who knows? And remember, you don't have spell check, so you can't blame that one on spell check. I think the student just I have a million of those from many years of teaching. Hysterical bailment, I always loved that. I had somebody write pages and pages many years ago about hysterical bailment. I thought that was pretty hysterical. I'm assuming the student meant a historical bailment, whatever a historical bailment would be, but it was hysterical bailment repeatedly. So do try to use the correct vocabulary. It helps. Other questions? Yes, ma'am.
For example, in this case, we're saying that the father left the apartment from Orange County and he had the intent to abandon because he was putting up for sale. But so in that case, it's considered abandoned just because of that. But what if he was considering to stay in Orange County, like what we discussed the other day, that if he's going to use that money that he's
Oh yeah, absolutely. Good question. Certainly not raised by this one. If I understand your fact pattern, it could be an interesting test question. So he puts the Orange County condo up for sale, moves back to Miami, but remember, he has established homestead in the Orange County condo while he's there. Let's assume that he did, because he was living there, it was his residence. Then he puts it up for sale, moves back to Miami, and then does succeed in making a sale, which he did not here. Then the question is, what about the proceeds from the sale? Of course, if he reinvests it within a reasonable time in a homestead, it retains its protection. Oh yeah, there is no, to the best of my knowledge, there's no requirement that he buy another homestead in Orange County. It's just it's got to be in the state of Florida. right? But I know of no restriction in terms of which county. But good question. Okay, anything else? All right, before we take the break then, let's go ahead and do a little bit of Florida evidence, particularly because it's a really good chance that you're going to have Florida evidence on your multiple choice. And I have just a handful of questions. These questions cover many, but not all of the Florida distinctions, but I've hit most of them, and then there's one that at some point I need to get into the question set that I'll mention because it involves a fairly recent change, which I think you probably all know anyway. So go ahead and let me get you rolling. Question number 1. Anybody else on this one? Do we have any? Okay, yeah, sorry. Okay, there we go. We have 11 in the room, so let's see how we did. Pretty good, not perfect. B is the right answer. Somebody who picked B, tell somebody who didn't pick B why B is the right answer. We're talking about, of course, a learned treatise in Florida. And, go ahead.
It can be, learned treatises can only be used in Florida in cross-examination.
In Florida.
Attack, you cannot use it.
Correct. Okay, cannot be used as it can, of course, under the federal rules, because there is a hearsay exception for a learned treatise under the federal rules of evidence, but Florida does not have that exception. So yes, you can use a learned treatise to impeach in Florida, but you cannot use it as substance. And I promise you, this is the type of distinction that they're going to test. They will look for all the places where the Florida rules differ from the federal rules. Question? It could. Now, I want to say one thing about evidence and essay questions. They have not, they've not had an evidence essay as an evidence essay since I think the very early 1980s, I mean a long time ago. But could you have something like that in the context of an essay about something else? Yes. I doubt seriously, I really doubt that you would have a standalone essay question. But could you have a component of a question that asks you to consider something evidentiary? Yes. Or procedural? Yes. So always, don't freak out if you see it, and make sure you have the vocabulary to address it. These are questions that I wrote. They're kind of old because you see the names there, Baby Bop and Barney. That was at the request of I don't remember which of my nieces, and they're adults now. So I wrote this question a while ago, but it still works. Well, I will tell you this about Florida questions though. You're going to see, and it's true still today about the Florida multiple choice questions. They are not written with the precision that is used to write MBE questions. Sometimes they look like MBE questions. A lot of times they do not. And sometimes they're just completely off the wall. You work with what you can when it comes to the Florida multiple choice, and you just have to try to let it not throw you too much. Okay? Any other questions about learned treatise in Florida? All right, number 2. Anybody else on this one? Seem to be stuck on 9. We may have some dead clickers. Anybody else going on? Okay. See what we got. Okay, folks, let's all gather around so we can get this essay done and you can all get back to your studies. Okay, we're going to do the same thing we did. Just take a few minutes, read the fact pattern, and then we'll talk about it. It's family law. Have fun. Just don't have too much fun. Good. Okay, let's go ahead and take a look at this question. And I'm going to suggest that should you get a family law question, which you might, I'm not sure it's the highest thing on my list, but if you get one, try to park the emotions at the door. Because whenever I do a family law question, you can kind of divide the room in half, and women on one side, men on the other. And sometimes I get people who must have had really serious breakups because the venom just drips off the page. Not particularly helpful. So just try to keep it as neutral as possible. All right, let's look at the facts. We've got husband and wife. They met in college and married after graduation. Now, it's an older question. I like it because of the issues it raises.